So, good morning. This morning's topic is rent arbitrations. That's officially what it's called, but actually it's about opportunities for insolvency practitioners. These are the topics that I'm going to be talking about. I'm going to start by talking about the current restrictions on business landlords, which are due to end in a few days' time from the 25th of March this year. And they're a bit like every business tenant in the country being in a sort of lightweight administration moratorium at the moment. And that's due to be phased out from the 25th of March. I'm then going to give you an overview of how the new law is intended to work. It will be called the Commercial Rent, open brackets, Coronavirus, close brackets, Act 2020. This is all somewhat provisional because I have got available to me only a draft of the new law. It's still at the report stage in the House of Lords, so there may yet be more amendments to it, and there needs to be a third reading in the House of Lords timetabled before the Act can be given royal assent. However, from what I've seen, I think the current draft is unlikely to change very much before it comes into force. I'm then going to be talking about the arbitration provisions in the new law, which are the ones that I think are going to be particularly important and interesting to you. And within those, I'm going to be looking at the key concepts of viability and solvency, because the arbitration is going to be really all about the tenant's viability and in some cases the landlord's solvency. And in cases that don't go to arbitration, the negotiation between landlord and tenant will be all about the tenant's viability and possibly the landlord's solvency. And I don't think there's a better group of people to get involved in a negotiation about viability than insolvency practitioners. I'm then going to finish off by talking about who the gatekeepers are going to be, who are the people who are likely to be first instructed by landlords and tenants in rent arbitrations, and therefore who are the people that it's going to be worth your while going to see, doing emails to, sending briefing notes to lay out your stall as purveyors of IBRs that will be finely focused and highly relevant to these sorts of rent arbitrations. Final topic I've got there in square brackets, because I'm not going to say anything about it at all, except just to say that another aspect in which this new legislation may be relevant is in the context of administrations, where rent is potentially going to be payable as an expense of the administration. And I'm as yet a little bit unclear as to what the implications might be for this. Probably not hugely relevant, because the rent that's going to be the subject of the arbitration is going to be pre-administration rent, but I suspect there could be some complications, but that's, I think, just a little too specialized to say very much about this morning. So on to the first of those topics, which is just to look very quickly and briefly at the current restrictions that there are on the enforcement of landlords' rights at the moment. And these are going to be phased out in a few days' time. The first is the landlord's remedy of forfeiture for rent arrears, the right to bring the lease to an end. At the moment, that's not permitted, and that applies both to legal proceedings to terminate the lease and also peaceable re-entry. As from the 26th of March, the landlord's rights for forfeiture will be reinstated, but will be restricted by the new Act, and the extent to which they are restricted will depend upon the circumstances of the particular tenant's business. Similarly, bailiffs can't be used for commercial rent arrears recovery in that until the 25th of March this year, landlords can send the bailiffs in only if there are more than 554 days rent in arrears. That's more than 6 quarters rent in arrears. Again, that right is going to be phased back in from the 25th of March. And similarly, at present, winding up petitions are restricted. Landlords have to prove extra elements to be entitled to present a petition, and that is going to change from the end of the month as well. And the new rent arbitration provision is intended to be a less restrictive moratorium, but still a continuing moratorium to replace the current one. So what's going to be in the new legislation? Well, essentially, it is going to act as a further suspension of landlords' rights for another 6 months. And in that time, either the landlord or the tenant can go to arbitration to get a binding ruling on how much of the rent arrears the tenant is going to be legally obliged to pay. And during that 6-month period, rent arrears recovery action is still suspended. The 6-month period itself may well be extended. So depending upon how the economy manages over the next 6 months, whether there are any further coronavirus lockdowns, and also I suspect how successful the rent arbitration scheme is and whether it needs more time to work effectively, all might result in a further extension of that 6-month period. So it'll be an opportunity for new work over at least 6 months and possibly a rather longer time than that. There are 2 key concepts that are going to be relevant for this, and tenants will be protected only if they're within these 2 concepts. The first one is that the rent arrears must be what's known as protected rent. And for it to be protected rent, it's got to have been during the protected period, and their tenancy will have to have been adversely affected by coronavirus. Now, the protected period will depend upon the type of business, and a tenancy will only be treated as adversely affected if the business or part of it or part of the premises were actually closed by government regulations during that time. So a tenant who's got unpaid rent and whose business has in some way been affected by coronavirus, but where the business has actually been open for the period for which the unpaid rent has accrued, they won't be able to use the rights given to them. And as far as they're concerned, the gloves will come off with the landlord in a few days' time anyway. The protected period will depend on the type of business. So as you can see from this slide, the protected period for hospitality and nightclubs, quite a long time, from the 21st of March through to the 21st of March 2020 to the 18th of July 2021, and slightly longer than that in Wales. For garden centres, on the other hand, the protected period then, the time when they were closed, at least in England, was from the 21st of March 2020 until early May 2020, so a very short time. And there's 2 pages of these slides. I will circulate them afterwards with the recording, this presentation. The arbitrator themselves has got quite a wide range of relief that they can grant to the tenant. So examples of what they're allowed to do is they can write off the debt in whole or in part and just release the tenant from an obligation to pay it. They can give the tenant time to pay the debt, and that might just be to say that all of it has to be paid by a particular date, or it may be that it will be payable over instalments, and they can reduce the interest rate that the landlord would otherwise be entitled to charge under the lease agreement. So that's an overview of how the new legislation works. Let's lift the lid on the arbitration provisions and have a look at those, because this is going to be quite fundamental to the tactics of both parties. This legislation has been built on two sets of codes of conduct. The first was published in June 2020, and the most recent one was published in November last year. And both codes of conduct encourage negotiations between the parties as a way of resolving the issue of the unpaid rent that the landlord owes. And the new legislation also has some real incentives on that. It will be either party's choice to start the formal arbitration process. And I can see that it might be in landlord's interest to start the process early if they want to start enforcing their rights and start being paid soon. And it might be in the interests of the tenant not to be quite so swift about it if they're looking for a bit more time to pay. But I suspect that the tactics of the timing could be quite sophisticated in many cases. So the way it works is, if the landlord wants to kick it off, or indeed if the tenant wants to kick it off, they have to give the other party a formal written proposal. And this really should be a best and final offer, or something very close to a best and final offer. And they have to give their evidence in support for that as well. So there's quite a lot of front-loading work that needs to be done before either party can make the formal proposal to start the arbitration process. The other party then has a short period of time to reply with a counter offer, which really ought to be their best and final offer. And if there is a counter offer, then the first party has the chance, the opportunity to then revise their original offer if they wish to do so. And there are incentives on them to do that. And then after that, if there's no agreement, the arbitrator is then appointed. And the party who kicks the process off has to appoint the arbitrator by approaching an approved organisation, and there will be a list of those, and that organisation then chooses one of their members to be appointed as arbitrator. So it's intended to be a fairly swift way of finding an independent and impartial person to be the arbitrator for this. And the arbitrator has to dismiss the application if the parties reach agreement first, as you would expect, or if it turns out that this is actually not a business tenancy at all, or if there is no protected rent due. So if there are rent arrears that the tenant owes, and the tenant is trying to use this arbitration procedure to deal with rent that's not been incurred during that protected period, this isn't going to work for them. And finally, the arbitrator has to dismiss the application if the tenant's business is not viable, and it wouldn't be even with any kind of relief. So if it's apparent that the tenant's business is doomed to fail if they have to pay the rent, and there is no prospect of them being able to pay rent in the future, then the arbitrator will have to dismiss the application. Will have to end the arbitration without making an award in anybody's favour, and the landlord will then be able to enforce their legal remedies against the tenant. As I said at the outset, this is really all about the viability of the tenant's business, and this is why I think an IBR is going to be so essential to this procedure. Now, in cases where the arbitrator thinks that the tenant's business is viable, then they have to decide whether the tenant should be granted some sort of relief from the unpaid rent, and if so, what that relief should be. Now, the arbitrator has only limited number of options. This is designed to be what's sometimes called a flip-flop arbitration, which means that the arbitrator doesn't shouldn't have the right to saw it in half. The arbitrator will have to choose one of the proposals in front of them, either the proposal that the tenant made or the proposal that the landlord made. And the purpose of that, of course, is it encourages both sides to make sensible compromises, to think about the other side's interest in all of this, and to put an offer which is as reasonable as possible, in the hope that the arbitrator will choose it. And of course, what you might find in many of these cases is that the advisors on both sides are telling their clients that they ought to go a little bit further than they want to. And by the time both of them have gone a little bit further than they want to in making their offer, there may be a very small difference between them, and it might be then quite easy for them to agree in negotiations to carve up that difference quite quickly. So that's the issues around arbitration provisions in there. Let's have a look at these concepts of viability and solvency. And again, this is going to be looking in some detail at the actual workings of the arbitrator's decision. First point here is that the arbitrator cannot choose a proposal unless it fits the statutory principles. And again, I think the purpose of this is to encourage landlords and tenants to get professional advice on what they're doing with all of this. Again, it's all designed as a way of getting the parties to agree a compromise whenever possible. And so a party who does not have proper professional advice, they're likely to present a proposal which doesn't really comply with the statutory principles, and the arbitrator will then be disbarred from choosing their proposal. So there really is, as I say, a big incentive on both parties here to get proper professional advice on how this process works, and to make sure that their proposals are ones that can be acceptable to the arbitrator. Now, if you have neither party being sensible here, and neither of the proposals in front of the arbitrator follow the statutory principles, and yet the arbitrator thinks that they should make an award in favour of the tenant, then this is the one situation where the arbitrator does actually have to write the proposal themselves, and does have to try and write something that does follow the statutory principles. But if one party has a proposal that follows the statutory principles and the other does not, the arbitrator has no choice. They have to choose the proposal that fits the statutory principles. And of course, the way it should work is that both parties should be properly advised. They should present a proposal that follows the statutory principles, and then the arbitrator has to choose between the two of them and choose the one that is the best fit. So what are the statutory principles? It is all about the viability of the tenant's business, with also a nod to the solvency of the landlord's business. And essentially, solvency of the landlord's business is the trump card. If the award would result in the landlord becoming insolvent, the arbitrator cannot choose it. So say it will be a trump card for the landlord here to say that, to provide evidence that their own business will become insolvent if the arbitrator were to choose the tenant's proposal. From the tenant's point of view, it will depend upon whether their business is viable at the moment, or whether it's not viable but could become viable. If it's a business that is presently viable, then the award should be one that preserves the viability of the business. If the business is one that could become viable, then the award should be one that will restore viability to the tenant's business and preserve it. But of course, the flip side to all of this is that if the tenant's business cannot be viable, then the arbitrator has to dismiss the application. So you see, the statutory principle, the main statutory principle, is actually the viability of the tenant's business. And what sort of evidence would you look to have as an arbitrator about the viability of the tenant's business, well, actually, an independent business review would be absolutely perfect. The arbitrator is actually told to assess the viability of the tenant's business from its assets and liabilities and from other relevant information. And the arbitrator, if the landlord's solvency is in question, the arbitrator has to assess the landlord's solvency on a similar basis. Now, the full detail of that is in the code of conduct, but I mean, essentially it's an IBR. And the tenant's evidence, the IBR commissioned by the tenant, will have to show that if nothing changes, the tenant's business will either remain unviable or it will become unviable. And it will also have to show that the tenant's proposal will be exactly the right change to make the business viable and to keep it viable, or depending upon the circumstances, simply to keep it viable. Now, you might find that the opportunities for you as an insolvency practitioner could be that you might be instructed to be an independent expert for the tenant, or you might be an independent neutral expert to assess both sides' evidence and then report to the arbitrator. And in that second role, you won't actually be the arbitrator, but essentially your conclusion and recommendations are likely to tell the arbitrator what decision they have to make. The landlord's evidence, and you might find yourself being commissioned by the landlord either to do an IBR on the tenant or to review and critique the tenant's IBR. If that is your role, you're working for the landlord, so to speak, the landlord's evidence will have to cast doubt on the tenants. So you might be showing that the tenant's business is not viable and can't be viable, in which case the arbitrator refuses the application. Or you might go in the other direction and you might show that the tenant's business is completely healthy, very viable, doesn't need any concessions at all, so the arbitrator makes no award. Or in most cases, because this is going to be a flip-flop arbitration and the arbitrator has to choose either the landlord's proposals or the tenant's proposals, it might be that your evidence will be showing that the tenant's business is actually not viable, but it can become viable and remain viable with the landlord's proposal. Now, there are things that the landlord is not going to be entitled to do. So the landlord cannot suggest that the tenant should restructure its business. So much though the landlord might like to suggest it, they can't say that the directors should sell the Range Rovers and cycle to work in the future. And similarly, the landlord cannot suggest that the tenant should borrow another £100,000, use that money to pay the rent arrears, and the directors should put their own homes up as security to do that. It's not just a case of security or guarantees. The landlord is not entitled to suggest that the tenant should borrow more money as part of their proposals. It's possible that the landlord's evidence might suggest that the tenant's proposals would make the landlord insolvent, which is a bit of a potentially double-edged sword to wield. It would mean that the arbitrator cannot accept the tenant's proposals. It would then mean that the landlord would be entitled to bring action against the tenant for payment of the arrears. But of course, if the tenant can't pay, then the landlord is still going to be insolvent. And you might also find that in a case like that, the tenant would also want evidence. Again, they might commission you to critique the landlord's IBR on themselves, or they might ask you to run an IBR on the landlord themselves to give different evidence to the arbitrator about the landlord's solvency. So really, these are the opportunities for instructions for you, either to provide evidence to support either side as an IBR, or to give an expert's appraisal of the other side's evidence or to report to the arbitrator. And that could be either that you do an IBR of the tenant as an independent third party, fully neutral, or it might be that you would be reporting to the arbitrator on the IBRs commissioned by both sides, to help the arbitrator work out which one is the more credible. And I think also there's going to be a need for you to advise in advance of an arbitration while the parties are still negotiating. And of course, getting in early at that stage gives you the best chance of winning a commission later for a full IBR. So that brings me on to the final topic here, which is to look at the gatekeepers, who are going to be the professional advisors to landlords and tenants from whom the work might come. And I can think of 4 sources of work for you from this. The first one is commercial property solicitors, the sorts of solicitors who deal with conveyancing for landlords and business tenants. Most firms of any size will have a commercial property department dealing with, say, non-contentious business property. And it's those who specialize in landlord and tenant work who you're going to be most interested in. Litigation solicitors are also going to be a potential source of work for you, particularly litigation solicitors who specialize in commercial landlord and tenant actions. Commercial agents, I think, will also be involved in this, in advising either side about how the procedure works, and helping them with the information that they would need and the arguments to present it. And also, of course, accountants of landlords and tenants, as always, are also likely to be a good source of work. So I think these are the people to focus your marketing activities on. These are the people to send briefings about IBRs, how they work, how to commission them, and their relevance to the new legislation, as I think any of them might well welcome the offer of support from an insolvency practitioner, because somebody who can say to them, we can do the report for you on viability, it's likely to be very well received. So I think that's now covered all of the points that I was going to cover. It looks like the half hour is up. So this is now a chance for me to ask if there are any questions. And I don't see any at the moment. So what I will do is I will say thank you all very much for coming on. Well, that's today's. That's the next coffee break briefing is the 4th of April, and it's going to be on leisure businesses. I will now say thank you all very much. If you have any questions, now I've just got one question has come up here, which is who chooses who an arbitrator instructs to advise on both offers? And that's a really good question. And I don't know what the answer is, but I suspect that might well be the arbitrator themselves would decide about that. So yeah, so again, I suppose that might be worth adding to the list of people to approach. Get hold of the list of arbitration organizations and contact them as well, and send them a brochure, an email, a leaflet about IBRs and how they work. Because if arbitrators are informed about IBRs and their significance in all of this, that will help them to do that work. So yes, excellent question. Thank you very much indeed for that, Mark. Thank you. And with that, I will now say thank you all very much and goodbye.